This- All right, sorry. So if you can hear me, hopefully there also is I think they're transcribing this as well, so that will be helpful. But the first case that I want to deal with, it discusses the issue of citizenship. So the story is of Dred Scott, and I don't know. I'm sure many of you have heard of Dred Scott, but if not, I'm just going to give a little background on Dred Scott. So Dred Scott was a case that cited in 1857. So this is during slavery. Dred Scott and his wife sued for their freedom in the state court of Missouri. And I know you're thinking, well, that's kind of odd. Why were you doing that? So you had the Missouri Compromise that said that if you went to a free territory and you stayed there a while, you can then sue for your freedom. And that was not actually uncommon in Missouri during this period. There's actually a great book called Redemption Song by Lee Vaudeville, who she writes about the different cases in state courts where blacks, slaves or enslaved blacks, were suing for their freedom. So what Dred Scott did here, he and his wife, was not unusual. They were in Missouri. They went to the north with their master. They stayed there a while. For whatever reason, they did not sue for their freedom. My guess is that they assumed that their master would free them once they got back. So they didn't sue for their freedom there, but then they eventually went back down to Missouri and sued for their freedom. And like I said, it's not unusual for them to do that. And they lost at the state level. And what makes this case unique is that it actually ended up going all the way up to the United States Supreme Court. And it was there, and Dred Scott, Dred Scott lost at the lower courts, just kind of as a little, for those who may not be attorneys, someone lost at the lower court because their name is the first in the case. So it's Dred Scott versus Sanford. Dred Scott lost at the lower court. And so he sues for his freedom, goes all the way up to the United States Supreme Court, and Chief Justice Roger B. Taney decides the case or writes the opinion for the case. And in the case, he votes and said not votes, but he says that you lose, Dred Scott, on a procedural ground. Now, again, just a little background for those who may not be attorneys. When the court chooses a case to hear, they can decide it on procedural grounds, which means like you didn't cross your T's, you didn't dot your I's, or you didn't do things procedurally on the steps going up. And so what the court said here is that Dred Scott is not actually a citizen and therefore does not have the right to sue. And the way that Justice Taney does this is he goes and looks at the history of blacks in America and in England, and he says this, a kind of he said they, meaning black people, have for more than a century before been regarded as beings of inferior order and altogether unfit to associate with the white race either in social or political relation, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. So, in other words, what Justice Taney was saying here is that when the founders of the Constitution wrote the Constitution, they did not envision black people as citizens, and therefore he could not sue for his freedom. Justice Taney also, in a very unusual step, went beyond just that and said, oh, by the way, the Missouri Compromise is unconstitutional because black people are no more than property. So we are no more than like your bed trying to sue you. And if you're going to take someone's property, to do that is a violation of the due process law. So here you have Justice Taney, the Supreme Court, saying to black people, you have no rights. The system was not set up to benefit you. We see you no differently than any other chattel. Now, this discussion is important because after that, because Justice Taney thought he was dealing with the whole slavery issue. That was what was being debated. He thought he kind of, that's out of here. I've settled it. I've called the Missouri Compromise unconstitutional. Black people have no rights. We're done. Of course, he was very wrong, right? He was very wrong. What ended up happening is the Civil War. And it was through this great violence that slavery eventually, as we have generally understood it, it came to an end. And then it ushered in a period known as Reconstruction for about 12 years. And Reconstruction saw great progress. And you had the 13th, 14th, and 15th Amendments that were passed are also known as the Reconstruction Amendments. And the 13th Amendment abolished slavery, kinda. What it said is that You cannot have servitude, unlawful servitude, or unless you are convicted of a crime, duly convicted of a crime of like a felony. So, of course, later on now, we're able to sort of lock people up and have them be in prison, which disproportionately affects African Americans because the 13th Amendment sort of had that clause that allowed if you are convicted of a crime, then you could be held against your will. So that's the 13th Amendment. It ended slavery in the sense of a very, well, we'll get to whether or not that means general or a system. You also have the 14th Amendment, which gave equal protection under the law, and it also conferred upon blacks or former slaves citizenship. Because all that terrible language that Justice Taney used in his opinion, where he said black people had no rights which the white man is bound to respect, that case has actually never been overruled. The Supreme Court never came back and said, you know, when we were talking about all that stuff, that was our fault. We were wrong. No, the Supreme Court has never said that. However, it is perceived that the 14th Amendment, by conferring citizenship upon black people, effectively overruled the Dred Scott case. And then you had the 15th Amendment, which is the voting rights, saying that you cannot deny people the right to vote based upon their race. Now, often people think that the 15th Amendment gave black people the right to vote, but that's not. In a later case, in 1876, United States versus Reese, the Supreme Court said, actually, no, you don't have, the 15th Amendment didn't give you what they call a positive right, meaning you have the right to vote, but rather what it said is you cannot deny people the right to vote based upon their race. This is important because later on you have cases like grandfather clauses and literacy tests, and even currently where you have felons who are not able to vote in the state of Florida. The reason why they're able to do that in part is because of this decision that happened fairly early on. So you have the Reconstruction Amendments, and then after that you have the Civil Rights Act of 1866. Yes, contrary to what many people believe, the first Civil Rights Act passed in this country was not in 1964, but rather was in 1866. A law that was trying to protect citizens and just kind of thinking about every different aspect of what does it mean to be a citizen, from property and contracts, and trying to protect that. And that's actually still good law today. The second Civil Rights Act passed in this country was in 1875. And that was to protect from discrimination in public accommodations and transportation. Because what happened, though, while you have all these great amendments and laws being passed, simultaneous with that, you have state legislators passing laws to segregate and to discriminate against African Americans. And so what ended up happening, which brings us to the next case that we have, is the civil rights cases of 1883. And so what the civil rights cases were is actually a collection of about 5 cases. And it was based upon the Civil Rights Act of 1875. And so some of these cases were like black patrons trying to go to the theater. They were denied. There was one black man who wanted to go see the Jubilee Singers. Now, if you know the Jubilee Singers, they're black. So it's a black man trying to see black singers. And of course, he was denied. And so what happened is these cases went all the way up to the United States Supreme Court, and the Civil Rights Act of 1875 actually conferred criminal penalties against people who were discriminated against blacks. So these were like criminal trials, and they sued and say, hey, this law actually violates the 10th Amendment, which is all rights not explicitly given to Congress belong to the state or states' rights. And so here, the United States Supreme Court had a chance to answer that initial question. What does it mean to be a slave? What does it mean? What is slavery in general? And so what the Supreme Court said is actually 2 things. One, the 14th Amendment only applied to state actors, meaning that it only was something that it was intended to protect citizens against state action. It was not intended to protect citizens from other private discriminatory actions. And this is actually in contrast to how the court ruled with like the Fugitive Slave Act. during slavery. During slavery, this court had no problem giving private citizens this broad power. But when it came to the civil rights and protecting liberties of black people, the court was like, oh, we don't, we can't do anything. That's just only state actions. We can't do anything when it comes to private citizens. And then the court also said some things about the 13th Amendment, because with respect to the 13th Amendment, it's like, well, if it's a badge and incident of slavery, if being discriminated against because of your race is a badge and incident of slavery, does the 13th Amendment protect me from being discriminated against? And the court, again, what is slavery, was saying, no, that's impossible. In fact, what the court said, and I'll just, again, share my screen so you can see the quote here. Oh, actually, I didn't have the quote. I'll read the quote, sorry. The court said, it would be running the slavery argument into the ground to make it apply to every act of discrimination which a person may see fit to make as his guest he will entertain, or the people he will take into his coach or cab or car or admit into his concert. So what the court is saying here is essentially is that you're stretching this slavery argument by saying just because you're discriminated against based upon your race, that has to do with slavery. That's a stretch you need to get over. In fact, the court then goes on to say, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the concomitants of the state, there must come a stage in the progress of his elevation where he ceases to be the mere favorites of the law, and he has the rights of a citizen or a man, his rights are protected in the ordinary modes of citizenship. So in other words, what the state or what the court is saying is like, look, you guys, not only does this not have to do, your discrimination not have to do with you being black or being former slaves, what it has to do, you actually have been given preferential treatment because of your status. Now, again, this is 1883. This is what, 20 years outside of slavery? So you're telling people who used to be slaves, former slaves, that if you're feeling like your discrimination is because of your race or because of your former slave status, that's inaccurate. You're stretching it. So what you're seeing here is the court is divorcing the history of slavery, history in general, with present discrimination, and saying instead it's whatever private citizens do or individuals do that has nothing to do with slavery. Instead, they're relegating it to state action. So the court is restricting these rights that were meant to be far more broad. Like the writers, the drafters of these Reconstruction amendments actually intended something to be far more broad than how the court is choosing to read it. Again, the court did not have to read it that way. They did not read it that way when it came to the Fugitive Slave Act, but they're doing it when it comes to protecting the liberty of black people. So then there's another case that happens in 1896 with Plessy versus Ferguson. And this was a test case, and I don't know if, again, I don't know how many attorneys we have on here, but test cases are cases that organizations sometimes try to find in order to bring an issue to the United States Supreme Court. And so Homer Plessy, was just a person. So let me share this screen with you so you can see him. So Homer Plessy is the person on the left. He was 1/8 black, or octoroon. His great-grandfather or grandfather was a Frenchman. He spoke French, well-educated. And then the person on the right is Ferguson, who was the judge in this case. And so Homer Plessy was a part of this citizens committee, and it's said in French because this is from Louisiana. And they wanted to challenge some of these segregation laws that were emerging alongside the Reconstruction laws. And so what they told Homer is like, look, we're looking to create a test case. So we need you, because there was a law called the Louisiana Separate Cars Act, which meant that the trains had to be segregated. And they said, we need you to get on a train, go to the white section, get arrested, so we can challenge this law. And that's exactly what he did. He got a ticket. He got into the white coach car, and then went to the conductor and said, hey, I'm 1/8 black, what are you gonna do? Because he was fair-skinned enough that he could get away with buying a ticket in the white cart. And so he got arrested, and he was before Ferguson, Judge Ferguson here, and that case went all the way up to the United States Supreme Court. And in that case, the court had to ask whether or not, sorry, whether or not the Separate Cars Act violated the equal protection of the law. And what the court said there is, no, it's fine. As long as it's separate and equal, then there's no issue. Just because you distinguish between the races does not mean that it is wrong. Again, as long as you have equal for both races. And then the court also said something here, because Plessy also raised the 13th Amendment, the badge and incident of slavery issue again. And the court said, look, if you feel inferior because you're being separated, that's not anything dealing with the law. That's because you choose to do that. That's in your mind. In other words, if you would just leave race alone, then race wouldn't be a problem. It's very similar arguments that are being made today. So you have the same thing going on with Plessy. The court says, nope, separate but equal. And this ushers in a very violent era in this country that we euphemistically call Jim Crow, but it was racial apartheid. So Plessy loses. The court again refuses to look at slavery beyond just the individual and says we're not going to look at whether or not the system, by creating these laws, are related to slavery. Instead, we're going to say that this is very different. And if you're seeing yourself as being discriminated against because of your former servitude, that's something that you're choosing to do. I meant to mention in the civil rights cases also, what the court said there is that, look, there were free people, or there were free blacks during slavery, and they never felt like any mistreatment was because of slavery. So why are you all thinking that? Which is odd, because it's kind of like, well, how do you, court of all white men who own, some of you own slaves, how do you know how free black people felt or believed in that moment? Did you take a survey? Probably not. Nevertheless, you're writing into your court cases that black people, how black people felt and how black people should currently feel. So with the case with Plessy versus Ferguson, again, it sets into motion this idea of separate but equal, and then it also removes the idea of slavery being a systemic issue. This is important because what happens is that you have these laws that are created that starts to segregate in different areas, and one area is within housing. And that leads me to my next area, which is the next case is Kramer versus Shelley, or Shelley versus Kramer, which is a case in 1948. And I'll just again share here so you can see. Shelley versus Kramer in 1948. Mr. Shelley, or J.D. Shelley, was a black man who lived in Missouri. He moved up from Mississippi with his family of 9, and he wanted to buy a house that was big enough for them. At the moment, he had a 3-bedroom apartment for his, like I said, family of 9. They obviously could not live in that. And so what happened here is, in the area in Missouri, in St. Louis, they had restrictive covenants. And I don't know if anyone knows what a restrictive covenant is, but it's exactly what it sounds like. It restricts kind of what you can do with your property. And in this case, it restricted what black people, or who you could sell your property to. And so white people had these restrictive covenants that said you cannot sell your property to black people or to Asian people. You could only sell it to other white people. And so, and this is important because you have this idea that the ghetto, or, sort of this segregated housing, is something that just magically appeared, that people just gravitated towards one community versus the other. But the reality is that ghettos were not magically created. They were intentionally formed by things just like this: restrictive covenants, redlining, and all of that forced black people into certain areas. And that was what was going on here with Shelley. His whole family and black people were forced into certain areas of town. It could only purchase property in certain areas of town. And so, but he needed more space. And I think the point of for him was when his daughter was assaulted in some way. So he's like, I got to get my family out of here. So he ended up connecting with a black realtor named James Bush, who wanted to help him. And James Bush created what he called a coalition a conspiracy rather of heroes. And it was 5 people. It was Mr. Shelley, Mr. Bush, a high school teacher, a minister, and Josephine Fitzgerald. And Josephine Fitzgerald was key here because she was a white woman who could purchase in these restrictive covenant areas. And what she did was she bought the house. This was the conspiracy. She would buy the house and then give it to Mr. Shelley, which is exactly what happened. And so they were able to purchase the home that they needed. It was a 2-story home, and it was a great time. Everyone was enjoying themselves until until Mr. Kramer, so Shelley versus Kramer, who Mr. Kramer was that neighbor, and everybody knows what I mean when I say that neighbor, that one neighbor that knows everything about everybody, that's in everybody's business. Mr. Kramer, who lived about 10 blocks away, somehow he saw that the Shelleys were in this neighborhood, and initially he thought, well, I think they're renters, but somehow, because he's that neighbor, he realized that they actually owned the home, and he immediately filed an injunction to get them kicked out of their house. And so he filed this injunction, and at the state level, the trial level, initially, the court threw the case out and said, look, you don't have enough, all the parties aren't here, so we can't enforce this. Kramer then appeals to the Missouri Appellate Court and wins. And then at this point, Shelley has brought in a prominent black attorney, and they're trying to figure out what to do. And they decide to appeal it all the way to the United States Supreme Court. And by this point, you have Thurgood Marshall. And Thurgood Marshall, with the Legal Defense Fund, he's really starting the practice of being a civil rights attorney, which people practiced civil rights before, but as an attorney who focuses on this, Thurgood Marshall is, this is right around the time that he's starting that practice. So he joins them to help overturn this restrictive covenant. And what they argue to the court is that this restrictive covenant violates the Equal Protection Clause of the 14th Amendment. Now, what Mr. Kramer's side argues is that this is private citizens. So remember, in the civil rights cases of 1883, the court said we can't really stop private citizens from discriminating against each other. That's not what the 14th Amendment is for. So that's what Kramer argued here. However, the Supreme Court said, look, had you just kept it amongst yourselves, then you're right. Yes, it would not have violated the 14th Amendment. But because you're asking the state to enforce it, now you have state action, and as such, it is unconstitutional. So this was a victory, and this is also during a period where you see some progress. So remember, Plessy is in 1896, separate but equal, where Jim Crow era is bad, but now we have the rise of the civil rights attorney and Thurgood Marshall, and they're trying to combat these laws, these discriminatory laws. So this is a victory. But again, what happens, so restrictive covenants are out. And by the way, the court in Shelley versus Kramer was unanimous, kind of, because 3 justices had to recuse themselves because they lived in neighborhoods with restrictive covenants. So that's how prominent this was during that time. But the 6 remaining justices, they all ruled that this was unconstitutional. But what ended up happening after this case, of course, is now you have other means, because just like during Reconstruction, you have all these great laws being passed, but simultaneously you have these laws meant to undermine it. Same thing happens with housing. And so whereas restrictive covenants that are done in a discriminatory manner, like here, was ruled unconstitutional, you still had other things, other means. There's white flight, there's redlining, things to resegregate communities. And so the issue is still coming up. So that was housing. The next major area, and the next case that I want to touch on, is Gamillion versus Lightfoot. And this deals with voting. Now, as I said before, the 15th Amendment does not give us the right to vote. It just means you can't prevent people from voting based upon their race. And so you had grandfather clause, which was eventually ruled unconstitutional in 1915 with this case called Gwynn. And then that leads to Gamillion. And Gamillion, Professor Charles Gamillion, was the professor at Tuskegee University and HBCU in Alabama. And he was engaged in activism. He would TCA, Tuskegee Civil Association, and he was a voting rights advocate. So he was signing people up, and over the course of like 20 years, in Tuskegee, let's say there was like 75 black people that were registered to vote. By the time of this case, which was in 1960, he had over 400 people registered to vote. And and there were more black people in this district were than whites. And then by the time of his efforts, he almost had black people, black registered voters were equaling that of white registered voters. So obviously, panic erupted in the white community and the White Citizens Council, which I don't know how familiar everyone is with that. That's really a racist organization. They were not having it, and so what they did is was a nice shaped district, and they devised this 28 side district. And I'll share. And this case, of course, deals with Jerry. So that's Gamillion, Professor Gamillion, and this is the district. I don't know if you can see quite the lines, but it was a 28 side district that excluded pretty much all but 4 black people out of it. So they were gerrymandering the district. And just a fun fact that I meant to, that I skipped on. The origin of the word gerrymandering, so it goes back to Massachusetts governor in 1812. His last name was Jerry. He did this funky looking district that you see, and a cartoonist drew it like this image that you see before you and said, look, it looks like a salamander. And someone said, no, you put Jerry and salamander together, it's gerrymandering. So that's how you got the word gerrymandering. And so that's what was going on here with this funky 28 side district. You have the White Citizens Council trying to systematically exclude all black people, so eroding their rights. What happened then is Mayor Lightfoot, and that's how you have Gamillion versus Lightfoot, he was trying to get this passed into legislation. Professor Gamillion gets word of that, and he's like, oh, no, you're not about to exclude. All my hard work is not about to go down the drain. And so as a result, what he did is they did a couple of things, like a little writing campaign, some boycotting, but the major thing that they did was they filed a case with the United States Supreme Court, or they filed a case for an injunction to stop the changing of this district. Obviously, because it's Gamillion versus Lightfoot, he loses, and it goes all the way up to the United States Supreme Court. And the Supreme Court had to decide whether or not well, first of all, I would also add that the city of Tuskegee never argued any kind of race-neutral reason for this. They never said, hey, we're not trying to discriminate. Their whole point was states' rights. We can do this. You can't tell us not to do this. This is states' rights. And so at the lower level, that's what the trial court agreed with them and said, yeah, they have the right. Making districts is a state-specific task. They can do this. So it gets appealed all the way up to the United States Supreme Court, and the Supreme Court says, yes, it is true that states have the right to create districts. However, it cannot do so in a way that violates the 15th Amendment. And this 28-side district that you created clearly violates the 15th Amendment because you're excluding black people from voting by really, like I said, literally only 4 black people were left in the district. So the district did not go forward. And again, this is one of those wins that you have from the period of Reconstruction where you have white people trying to undermine the black vote by gerrymandering and the Supreme Court stepping in. And this is also a more liberal court. This is the Warren Court. So obviously they're reading the laws in a more broad and systemic way anyway, in general. And so they win. This is a victory. But again, we know from during the period of before Gamillion, which is like the grandfather clause, literacy tests, all of that, we know from before that what happened with Gamillion didn't stop the efforts to prevent black people from voting. Even presently in the state of Florida, you have the governor redrawing districts and that excluding black people. And so now that's another issue. And the United States Supreme Court is picking up a voting rights case as well. And this case happened before the Voting Rights Act of 1965, obviously. So there are two, I argue, two important boxes in this country. There's the voting box or the ballot box, and then there's also the jury box, which brings me to the next area, which is the criminal justice system, and another major case that I want to discuss that deals again with this whole idea of systemic versus individual, or that question that I pose: slave. What is a slave? What is slavery? And that case is Batson versus Kentucky. Now, Batson versus Kentucky, like I said, deals with the jury, and I just want to back up too, because the history of trying to exclude black people from the jury box goes back to 1880 in a case called West Virginia versus Straughter, where West Virginia had a law that said no black people could serve on the jury, and the Supreme Court overruled that. And then you had the case of the Scottsboro Boys, which actually produced two Supreme Court cases, and one of them was about excluding the black people from the jury. And even though they didn't have a law in Alabama that said black people couldn't be on the jury, they somehow never managed to have any black people on the jury, and the Supreme Court said no, that's not right. And so here we are again in 1986 with Batson versus Kentucky, where this black man, Batson, was charged with the crime. He said, look, I was doing things, but I didn't do what they accused me of. I want to fight this. He's tried by a 26-year-old white man who's a prosecutor, and the first trial, because he had two, was a hung jury, and it was hung because the only black member on the jury hung the jury. She's like, I just didn't think there was enough evidence. And so after that, he's retried, and this time the prosecutor says, I'm not going to all the black people, and he uses what's called a peremptory challenge. So just backing up about the criminal justice system, during what's called voir dire, or voir dire, if you're from the South, where you're choosing your jury, you have what are called cause challenges and peremptory challenges. A cause challenge means I want to strike this potential juror because either they're biased, like they know the judge, or they know the defendant or the plaintiff, or they think that police officers can never lie. So, you obviously don't want them on a police brutality case. So those are your cause challenges. It could be also, I have a disability, I can't sit for a long period of time. Those are cause challenges. You have an endless amount of cause challenges. The other peremptory challenge is I want to strike you for any reason. It doesn't matter. Whatever the reason is, I can strike you. And this is something that actually dates back hundreds of years. It's not something that originated within America, but it's something that we have carried on over. So in this case of Batson, you have the prosecutor, when he knocks off all the black people, he's using his peremptory challenges to knock them off. And Batson leans over to his attorney, who's also white, and says, look, you should object to that. And the attorney's like, look, he has a peremptory challenge. You can knock him off. He doesn't need a reason. This is a losing objection. He told him, object anyway. He objects. Thank goodness he did, because it preserved a very important issue. And so, because what ended up happening is they struck all the black juror members, and that left only Batson as the only black person in the whole trial. The judge was white, the prosecutor was white, his attorney was white, and all the juror members were white. And so he loses, and he wants to appeal it, and he gets thrown to another public defender's office, who says, well, let me see. They do a tour of the different jurisdictions to see if other jurisdictions are actually doing the same thing with their peremptory challenges. In other words, are they using their peremptory challenges to strike black people? Or is it just happened to be unique here? And what they found is, yes, they're using their peremptory challenges by and large to strike minorities off the jury. So then they appealed that issue to the United States Supreme Court. And what the Supreme Court here said here is that, look, we do value the peremptory challenge, and that should stay, but it must be balanced with the need and desire to not have a jury full of discrimination, or a jury as a result of discrimination. So they end up overturning his conviction. But what happened here, and what was significant, is the concurring opinion by Justice Thurgood Marshall, the former civil rights attorney, who is now sitting on the bench. He concurs in the opinion because what the court created is what's called a Batson challenge. So if you're in jury selection now, and someone strikes a black person, you can ask them for a race neutral reason, and they have to give a race neutral reason, which sounds good in theory, but the reality is you can give any kind of reason. And Justice Thurgood Marshall, he understood that and said, there's a danger. What we've created here is a danger. And I'll just read his quote here from the Batson concurrence. He says, any prosecutor can easily assert facially neutral reasons for striking a jury. Trial courts are ill-equipped to second-guess those reasons. How is the court to treat a prosecutor's statement that he struck a juror because the juror had a son about the same age as the defendant, or seemed uncommunicative, or never cracked a smile and therefore did not possess the sensitivities necessary to realistically look at the issues and decide the facts in this case? If such easily generated explanations are sufficient to discharge the prosecutor's obligations to justify his strikes on non-racial grounds, then the protections erected by the court today may be illusory. And I don't know if you saw that too, but when he gave those examples, those weren't just random examples. He's referring to other cases where they use it. The person didn't look right, or the person had a son about the age of the defendant. And what Thurgood Marshall is saying here, and what I have found when I practice law, is that this Batson rule, which is meant to protect against racial discrimination in the jury selection process, in reality is illusory, because you just have to give, again, anecdotally, someone said, well, they struck a black woman from the jury, and they said, well, she works for the post office, and I had a bad experience with the post office. Like, who hasn't? Like, that's common, like a common experience. Another person struck someone because they had a Bob Marley T-shirt on. And the judges have allowed that. And so I only think one time did I see a judge sort of not give into the explanation given by the other side. But otherwise, they are systematically trying to remove black people from the jury. And even though the court here tried to make it seem like we're going to protect against this sort of systemic issue, the reality is that what they did is create an illusory protection that did not help. And so, like I said, Batson his case was overturned. He ended up being friends with the prosecutor that prosecuted him in the end, and he kept his life clean. So the last case that I want to talk to, because I only have limited time, it also deals with the criminal justice system, but it deals with the issue of the death penalty. And I kind of wanted to bookend this case with Dred Scott, because this case, McCleskey versus Kemp, is often seen as a Dred Scott case of our time. And what happened here is McCleskey was accused of killing an undercover officer. And this is a 1987 case, by the way. So the year after Batson, you have this case. He's accused of killing an undercover officer, and he is sentenced to death. And what the NAACP, because they're looking for a case that would end the death penalty in the country, they're waiting to. So as a result, they see this case and they say, okay, we're going to get with this professor named David Baldus, who created a study that looked at the data in Georgia, and to see if sorry, just a minute, just my dog is having an issue. Sorry, just a minute. I apologize for that. He was not happy with me. He wanted to be a part of this lecture. But sorry, so the case in McCleskey versus Kemp, Professor David Baldus looked at the data in Georgia, and what he decided to do is to see, did the race of the victim, or did that affect the outcome? And what he found out is that if a victim was white, then the perpetrator was 4.3 times more likely to be sentenced to death than if the victim was any other race. In other words, the system valued white life more than it valued any other life. And so people, of course, didn't appreciate that, or the court said, look, I don't know about your study, I can't, and Professor Baldus said, look, if you want me to run the data any other way, I can do that. And so he ran the data different ways, and it actually showed even more bias in the system. So the NAACP said, great, we're going to take this data to the United States Supreme Court. And when it got to the Supreme Court, what the Supreme Court said, look, we accept the fact that there is bias, that you show that there is bias in the system. However, we can't do anything about that beyond, actually, to quote the Supreme Court here, what it said is, just a minute. It says petitioner's claim, taken to the logical conclusion, throws into serious question the principles that underlie the entire criminal justice system. So, in other words, if we take this concern that you raise us, if you raise this systemic issue and we actually deal with the systemic nature of the problem, then it would throw the whole court system into chaos, and we don't want to deal with that. Instead, what we're going to do is throw the issue back on you and say that you have to show us that this particular prosecutor or this particular juror member wanted to discriminate against you. And so it shifted the burden back from the system to the individual and said, unless you can show that, yes, we recognize that there's bias, that's some degree that's going to happen. We can't do anything about that. That's on you. Again, it goes back to that case of, is slavery a matter of personal autonomy or is slavery a matter of a system? And again, the court is saying it's a systemic issue. We don't want to deal with it. We're going to put it back on you. And I will leave with the quote from Justice Brennan, who I think was very pertinent here. He really critiqued the court's case. He gave a dissenting opinion, and he said, taking on its face such a statement that the court just said, such a statement seems to suggest a fear of too much justice. The prospect that there may be more widespread abuse than McCleskey documents may be dismaying, but it does not justify complete abdication of our judicial role. The Constitution was framed fundamentally as a bulwark against governmental power, and preventing the arbitrary administration of punishment is a basic ideal of any society that purports to be governed by the rule of law. So, I hope I stopped sharing. So there you have it. Justice Brennan saying, look, the court, they have a fear of too much justice, but it is our judicial role, according to Brennan, that we must combat that issue. We can't shirk our duty and say it's a matter of the legislator. If we see injustice in the system, we must address that. So then again, I go back to my question. I would conclude with this. It's slavery and therefore discrimination in general. What does that mean exactly? Is it an individual matter or is it a systemic matter that we must deal with? If it's a systemic matter, then how has the court historically addressed it? Has it done a good job? Or is it perpetuating a system that really has its origins in slavery? And also, what is the importance of history when it comes to addressing discrimination? Is it something that we should quickly forget about, or is it something that we should presently consider when addressing the issue of civil rights in this country? And with that, I'm over. Again, I apologize for my dog who was whining, but I'll take any questions if you have any.
Oops, there we go. Hello. Thank you so much, Brooke. That was really, really fascinating. And we've been getting some comments about how unbelievably interesting your presentation is and has been, and it really outlines so deeply how racism is, how this country is built on racism and how difficult it seems to be to extricate all the different facets that are, systemically rooted in racism from that. So yes, please ask questions in the chat if you would. And you asked some really interesting questions towards the end, and that is a question that was new to me that I had never thought about. Is this an individual issue? Is this an issue that lies with individuals, or is it an issue that lies within the system and within the history, of our country? So who would like to start with a question? There's one right there that says, how do we fight gerrymandering in Florida? That's a wide question.
And the thing is, I don't know if you necessarily even want to take that issue to this Supreme Court, because they're very conservative leaning. Um, and so, I mean, one way obviously though is still to challenge it through the courts, but then also to press Congress to pass the to buttress our voting rights, because there's obviously the sunsetting feature of the Voting Rights Act of 1965, but we should be able to really press the legislature, press Congress to protect our rights. Why should that be something that's even has a sunset feature to it? If we see this consistent nature in our country to try to undermine the right to vote, then we shouldn't be removing that feature unless some magical way we have eradicated ourselves from racism.
Mhm. Okay, this is an interesting question. Are we in danger of Plessy being overturned post Roe?
That's a that's a good question. So actually, one of the senators, I think from Texas, wrote on his Twitter that now let's do the same thing with Plessy. The reality is anything's possible with this court. There's no such thing as settled law, and I think the Dobbs decision, which overturned Roe, really highlights that. You have this idea that like what precedent means that you can't overturn it, but I think with this court, if they're especially with their originalist ideas, who's to say? I mean, I would hope not, but the reality is I don't know with the court that we have.
Okay, here's a question that asks if you think that Black people have progressed in the judicial system, criminal justice, housing, employment, et cetera, or is it just sort of pro forma?
Say that again.
Do you think that Black people have progressed in the judicial system, the criminal justice, housing, and employment? Are there actual improvements, or is it, you know,
I mean, there is improvements, right? Like Jim Crow technically is better than slavery, right? But that doesn't make it good. And so we have made some improvements. Obviously, we're not walking around, I'm not walking around enslaved in chains. But there's still issues. Like when I was practicing civil rights and employment discrimination cases, many of those cases were thrown out at the summary judgment level, which meant that they didn't even go to trial. They didn't even have their day in court because a judge, who's often a white male, would decide these motions, these summary judgment motions that said, well, no reasonable person, no reasonable jury could find discrimination here.
mm,
So they're thrown out. So what I say about the Civil Rights Act of 1965, 64 and 65 is that you have like this beautifully constructed house on the outside. It says you know you can live here, but when you go in, like it's a mess. There's the carpeting is pulled up, the plumbing is busted, and it's not inhabitable. And that's kind of where we are with the state of things, because you have these courts which were largely a lot of the judges largely appointed by Republican or conservative leaning presidents, and therefore they're conservative leaning judges who have interpreted the teeth out of it, similar to what the court did again with the civil rights cases in 1883 and the civil rights and the Plessy versus Ferguson. They really took what was meant to be very corrective and protective and interpreted the life and are interpreting the life out of
mm.
the Civil Rights Act.
That's very true. We have a lot of questions here around the Supreme Court, and I think this is a very, now kind of issue. And you touched upon a lot of the Supreme Court rulings in your presentation. Um, Here's one that says, do you think President Biden should add justices to the Supreme Court in order to balance it out?
Absolutely. I mean, nine is an arbitrary number. It's not a constitutional number. And
Right.
obviously, we see that the court is, first of all, you have some of the justices that were stolen. When President Obama was the president, he could have appointed someone that would have tilted the court the other way, but the Republican led Congress prevented that. So, in order to balance things, I don't see a problem with expanding the court so that a decision like Dobbs does not come down. And now, like I said, they're bringing are going to hear a case on voting rights in the next session. Now would be a great time while while they have both the House and the Senate to get some of these nominations passed So absolutely.
Yes, I happen to agree with that as well. Um, Let me see what else we have here. And
I
the same
can't get a
people,
question in.
what's happening? Um,
Use the chat, lady.
I'm trying to convince people that black on black crime is a racist remark. It should perhaps be poor on poor crime. What language change help in attitude, if not legal changes?
Yeah, I mean, obviously, if like we have a lot of these mass shootings, for example, they don't call it white on white crime. I think yes, black on black crime is definitely meant to sort of further stigmatize black people and to perpetuate this idea of inherent sort of criminality of black people, that that kind of crime is unique to us. But the reality is, most people are harmed by people they know within arm's length, and those people
Mhm.
who are in arm's length normally look like you. So it's not unique. And I think I even have a problem with using poor on poor. Just call it crime. That's what it is. It's
Yes,
just crime. So just call it that. When you make these distinctions, what are you really trying to do? You're trying to, again, like I said, perpetuate notions of racism, of black criminality, in order to undermine any kind of argument. Because that argument is often used when police kill black people. They're like, oh, what about black on black crime? And it's like these two things have nothing to do with each other. We can deal with violence in a community, because that's what it is, and as well as state or police officers gunning down unarmed black people. These are not mutually exclusive.
right.
So is language meant to demonize and to shut up populations?
Yes, and also to put blame on black populations
Absolutely.
for circumstances that they often have no control over. Descendants of Plessy and Ferguson met recently, didn't they? Are any of their reactions of interest that you know?
I do remember hearing a podcast about this, and what I was more, um, what was more fascinating to me is that the information about Justice Taney and how he actually did not see himself as a racist and as an anti-slavery advocate, which was or not anti-slavery, but something along those lines. But I can't recall the dynamic between the two families, but I do remember, not Tawny, but I do remember hearing about the two of them meeting.
Mhm. Okay. Here's a question that you may or may not know about, but it's interesting. Anthony Crawford was lynched in 1920 in South Carolina because he demanded a fair price for his crops. His property was sold to Euro origin farmers. Descendants are still alive. Has anyone tried to right that wrong? There
I have,
must be many cases like that, though.
yeah, and I have
Yeah,
never
yeah.
heard of that. I mean, to me, one that's similar is with the Ocoee massacre that happened, where black people were run out in during the voting, the election night of 1920. Hundreds of black people ran out of Ocoee. Their land, which now has like multi-million dollar property, is gone. Some people still have the deeds, but they have tried to go through the courts, but the court, of course, is saying, statute of limitations, adverse possession, all of that good stuff that has prevented them. I would imagine, I don't know because I'm not familiar with this case, that something similar probably happened, but they will meet the same kind of restrictions in the court. But that does raise an issue of like, well, if I couldn't have sued for my property back then, can you really say statute of limitations
Mhm.
prevented that? And then at what point does statute of limitations actually kick in, if it does kick in at all, for a wrong like this?
Well, exactly, which would, if it did, it would make a case against reparations, which, would definitely, was a whole nother lecture.
That is indeed, indeed.
Well, Brooke, thank you so much. People have been asking if they can get the recording. We're definitely going to send the recording out to everyone who registered. And also people are asking if you could share your PowerPoint.
Oh, absolutely. And I have a list of books too that I can include. And then I have a website and a podcast. So palukisworld.com. And then my podcast is The Untold Story of the Civil Rights Movement, where I go more in detail to in more cases than that. Because obviously I didn't have enough time to even touch on a fraction of the civil rights case.
Mm,
but you can go there to hear more or read more on
That'd
that.
be great. And if you want to send me those links, and I can make sure that they get disseminated as well. Everyone, thank you so much for coming. If you'd like to unmute yourself and say thank you, hello, goodbye, please do so. And
Thank you, Brooke.
You.
Thank you.
Thank you.
Very, very,
Thank
very
you.
blessed.
Thank you. You are amazing.
Thank
Yes.
you.
Great night.
Excellent talk.
Yes,
And
excellent.
beautiful.
Thank you so much.
Great job.
Thank you
Great
so much.
job,
Yes.
Brooke Biz.
Thank you.
Yes.
Thank you.
Good night.
thank you
Good
so much,
night.
everyone. Thank you, Brooke.
Smart and beautiful.
Aw.
Love you. Love you, Brookie.
Thank you.
Take care. Hopefully we'll see you all at the next one.
Okay.
Will
I'll be there.
This is the
Thank
lady that
you.
funded. Oh, okay. Oh, wait a minute.
All right. Bye, LT.
Bye-bye, everybody.